Welcome, everyone. Welcome to today's webinar hosted by the UCLA School of Law Native Nations Law and Policy Center. My name is Lauren Van Schilfgaard. I'm an assistant professor here and very excited to welcome all of our panelists as well as you to our most recent iteration within our webinar series that has basically spent all of our time debriefing the host of Indian law cases that have been dropped by the US Supreme Court this term. First, as a matter of welcome, I am coming from Burbank, California, which is the homelands of both the Tongva and Tataviam. UCLA would also like to acknowledge the Gabrielino Tongva peoples as the traditional land caretakers of Tovangar, also known as the Los Angeles Basin and the Southern Channel Islands. We pay our respects to the Hunukvatum, or the ancestors, Ahiharum, or the elders, and the Iuhinkum, our relatives and relations, past, present, and emerging. Today is hopefully going to be the last debrief for the final and really damning Supreme Court decisions regarding Indian law. We have an incredible panel as well as moderator to lead our discussion today in Arizona v. Navajo Nation. First, I'd like to welcome Heather Tanana, who is a citizen of the Navajo Nation and an assistant professor and Wallace Stegner Center Fellow at the S.J. Quinney College of Law. She holds a J.D. from the University of Utah and a master's in public health from Johns Hopkins University. Heather is experienced in state, federal, and tribal courts. Much of her work focuses on tribal water issues, from climate change impacts to the Colorado River management. She leads the Water and Tribe Initiative's Universal Access to Clean Water project. She is also author for the Water chapter in the 5th National Climate Assessment. Secondly, I'd like to welcome Heather Whiteman-Rensham, who is an enrolled citizen of the Absolute, or the Crow tribe of Montana. She is the director of the Tribal Justice Clinic and associate clinical professor at the University of Arizona Rogers College of Law. She also teaches courses on tribal water law and tribal courts and tribal law. Heather previously worked as a senior staff attorney at the Native American Rights Fund in Boulder, Colorado, and served as joint lead counsel for her own tribe on a wide variety of legal issues, including the final phase of negotiation and approval of the Crow tribe's water rights settlement and preliminary implementation of the settlement. Thirdly, Professor Matthew L.M. Fletcher, a member of the Grand Traverse Band, who is the Harry Burns Hutchins Collegiate Professor of Law at Michigan Law. He teaches and writes in the areas of federal Indian law, American Indian tribal law, Anishinaabe legal and political philosophy, constitutional law, federal courts, and legal ethics. And he sits as the Chief Justice of the Pokagon Band of Potawatomi Indians and the Porch Band of Creek Indians. Most recently, Matthew wrote 2 articles, a case preview and an argument analysis for this case, Arizona v. Navajo Nation, on the SCOTUS blog. Both articles are linked on our events page as well as Turtle Talk. Fourthly, we feature Paul Spruhan, who was a former panelist on another case, highlighting both the cross-cutting but also intimate way in which these cases are impacting Indian country. Paul serves as the Assistant Attorney General in the Litigation and Employment Unit at the Navajo Nation Department of Justice. He received his AB in 1995 and his AM in 1996 from the University of Chicago. He went on to receive his JD in 2000 from the University of New Mexico, where he graduated Order of the Coif and received an Indian law certificate. He and his wife have 2 children and live in Fort Defiance, Arizona. Last but not least, I am excited to feature our moderator for today, Micah Urandi, who is Dene and is the San Manuel Band of Mission Indians Director of our Tribal Legal Development Clinic here at UCLA School of Law. She previously worked as senior attorney at California Tribal Families Coalitions, where she worked on ICWA, tribal child welfare, and California dependency issues, as well as a long resume of experience in Indian country. I'm really excited that you're all here to join us today for this debrief, and I warmly turn it over to our moderator, Micah.
Thank you, Professor Van Schilfgaard. I see a lot of friends, family, and relatives on this Zoom call. So just by way of quick introduction, She'e Micah Yurandi Yinshia, Luka Dana Anishle, Tohana Bashichin, Ashinya Deshiche, Tohiglinia Deshinala. As Professor Van Schilfgaard already shared, we are very excited to have this esteemed panel here today to discuss this very important case, the Arizona v. Navajo Nation case. Before jumping into the panel and starting with our first panelist, I wanted to let folks know that you will have an opportunity to share any questions that you may have for all of our panelists. If you go to the bottom of your Zoom screen, you will see that there is a Q&A function. Given the size of our panel today or our webinar today, we have limited the chat function, but please feel free to drop in any questions that you have in our Q&A, and we will be sure to make sure that they are answered accordingly. And lastly, we just wanted to remind folks that the Supreme Court heard this case on March 20th, 2023. After that hearing, or after the oral arguments, the Native Nations Law and Policy Center also hosted a panel on the oral arguments. We encourage you to re-listen to that panel, as a lot of the discussion today, as well as the decision, really focused on some of the panel input and guidance or comments from that last panel. And we will drop a link in the chat to the UCLA School of Law's YouTube channel, where you can find that webinar recording. Before we get started, again, I wanted to just provide some little background. The decision on Arizona v. Navajo Nation was released last Thursday, June 22nd. It was a 5-4 ruling against the Navajo Nation. And as panelists will further share, the majority's decision was only 13 pages long, whereas the dissent written by Justice Gorsuch was 27 pages. Some things pointed out in the dissenting opinion includes what the Navajo Nation's actual claim was. And as Justice Gorsuch pointed out, the actual claim was, should the U.S. assess what water rights it holds on behalf of the nation? And if so, should the U.S. devise the plan? With that, I would like to turn it over to our first panelist, Paul Spruhan, to share a brief history of the case. I would also like to ask Paul, who resides on the Navajo Nation. The nation just celebrated the treaty days, where the 1868 treaty was displayed on the Navajo Nation Museum. Being that it's been 155 years from the signing, could you share the importance of the treaty for the Navajos and in this case? Thank you.
Hello, can you all hear me? Yes, okay. It's sort of intimidating seeing how many people in the participant, particularly since I know so many of them. But I would be remiss if I didn't say ya'at for all the nah out there watching this, also to a lot of our DOJ attorneys who are on here. To properly give sort of a background of this case, I want to honor and acknowledge and give a shout out to all those people who worked on this case for 20 years, since 2003, when this case was originally filed. And I'm going to mention some people, I may omit some people, but Stanley Pollock, who I believe is on, Kate Hoover, Scott McElroy, Alice Walker, Michelle Brown-Yazzie, of course, our attorney generals who have seen this case through for the 20 years, Louis Dennett, Sosie Harrison, Sosie, Ethel Branch, Doreen McPaul. And this has been a saga. It's been a 20-year saga, first filed in 2003 concerning 2001 surplus guidelines, and should give you a sense of where we were. 22 years ago, they were talking about surplus guidelines for the Colorado River. And it was originally filed as both a NEPA case, National Environmental Policy Act, and as a breach of trust case. Went up to the Ninth Circuit twice before it went up on cert to the United States Supreme Court. Involved a lot of interveners, the state of Arizona, you may have heard of them, state of Colorado, a number of water users associations were quite interested in this case for a number of reasons, which we can get into. The NEPA case was, the NEPA claim, that is, was kicked on standing grounds. The Ninth Circuit affirmed that. But in going up to the first time to the Ninth Circuit, there was this sort of, fairly arcane, I suppose, depending on your point of view, question about whether the second sentence in Section 702 of the Administrative Procedures Act provided a freestanding waiver of immunity, or whether you had to establish first there was final agency action by a particular agency before you could invoke that. The Ninth Circuit resolved what had been quite a conflict within the Ninth Circuit with dueling opinions that said sort of different things, essentially saying 702 is a freestanding waiver, and therefore a common law, federal common law, breach of trust claim could be brought and there could be a waiver, and therefore reversing the original district court decision that dismissed the case on sovereign immunity grounds. It went through not once, twice, but 3 amended complaints. So the posture of the case as it made it up to the Supreme Court was whether it would be futile, whether to be futile to amend the complaint, which is when you ask for leave to amend the complaint. That is the standard upon which the district court is supposed to be looking into it. Is there any way you could fix this complaint that would render it valid, at least on a threshold 12b1 and or 12b6 standard? And the district court said, no, there was not, and specifically said 2 important things, both of which became relevant to the Supreme Court. The first had to do with whether or not there was, in fact, a cause of action for breach of trust. Sub-question, whether or not the so-called Hickory standard applied, which was a Tucker Act monetary damages standard, it would have appeared, whether you have to sort of, as a threshold matter, submit a specific or express, depending on your point of view, and Kavanaugh sort of talks about it in both of those in his majority opinion, trust duty for a specific thing that the United States is supposed to do. And if you can do that, the second part of that test, which Gorsuch talks about in some detail, is, and therefore can it mandate money damages? How do you glom that on to what this case was, which was a non-monetary damage injunctive type of case? And the second time it went up to the Ninth Circuit, because the district court dismissed it again, this time saying there's no common law breach of trust, there's no express or specific duty. Oh, and by the way, what the Navajo Nation is asking for improperly seeks a modification of this case called Arizona v. California, which of course is a decree Arizona filed in 1952. There's a lot of historical discussion in the case about this, seeking an adjudication of its rights vis-a-vis California because it did not want to abide by certain allocations and did not want to then move forward with a lower basin compact. And there's a lot of discussion of what the United States did and did not do when it intervened on behalf of itself and the tribes in Arizona v. California. To come to a sort of general summary, the district court said, what you're seeking is unduly impacting the original jurisdiction of the Supreme Court, because when the Supreme Court issued its decree in Arizona v. California, there was a clause reserving to itself jurisdiction to do certain things, modify, et cetera, and the court said this is an attempted modification. Too bad for you, goodbye. And then there's this sort of arcane discussion, which again is sort of buried in a footnote in Kavanaugh's discussion, but was a major issue when Arizona filed its own cert petition. Is this reservation of jurisdiction in the decree in Arizona v. California a subject matter jurisdiction threshold, or is it not? And Kavanaugh eventually said in the Supreme Court opinion, buried in footnotes, which of course I think all the real action is footnotes. That's my general theory about these things. And there are some very sexy footnotes in this case. Basically said, that's not a subject matter jurisdiction question, so we don't have to get to it. Thanks, goodbye. Okay. So it went up to the Ninth Circuit based on the dismissal that it improperly attempted to do an end run around the Supreme Court's reserved jurisdiction and that there was no cause of action on breach of trust. The Ninth Circuit the second time said, well, wait a minute, we don't necessarily think the Hickory standard applies here, and therefore those cases in precedent aren't directly applicable. So what did it say? It said Winters plus this provision of the Treaty of 1868. By the way, here's the most famous painting in rendering of the signing of Treaty of 68. There's Sherman right there. And then I believe that is the signatory Delgadito, who could sign his name in English, signing the Treaty of 1868. Okay, so the Ninth Circuit basically said there is an enforceable trust obligation, or at least there is a cause of action to so establish based upon the Winters doctrine, based upon Article 5 of the Treaty of 1868, which provided for the implements and farming for people who essentially in a proto-allotment situation could set aside land on the reservation that was being created by the Treaty of 1868, plus the pervasive controls specific to the lower Colorado River pursuant to the Boulder Canyon Act and the law of the river. And so there's a lot of discussion about the law of the river and all this other stuff. That Colorado River uniquely among rivers is directly controlled, pervasively controlled by the Department of Interior. And this issue of whether control itself is relevant for the initial discussion, whether there is a cause of action of breach of trust, is sort of, atmospherically being discussed. And you can pick it out of Kavanaugh and Gorsuch's opinion as well. And then it made its way up to the United States Supreme Court. Now, importantly, who filed for cert in this case from the Ninth Circuit? One, the state of Arizona and its interveners. It actually jumped the line and filed first. Hence, the official name of the opinion is Arizona versus Navajo Nation. The second cert petition was by the United States itself, by the Solicitor General in the name of Holland and others within the Department of Interior. So the United States sought the United States to reverse the Ninth Circuit's opinion that in fact there was a cause of action for breach of trust, and they were successful. And if you read Kavanaugh's opinion, it's almost as if it's coming directly out of the brief. Indeed, he says so, as the Solicitor General says, quote, blah, 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 blah. So anyway, that is a summary of where we are procedural. The Treaty of 1868, incredibly important, as Mike has indicated there was. Every year we do treaty days. A few years ago, the original treaty came from the National Archives to the Navajo Nation Museum. There's now a replica in that treaty room in the Navajo Nation Museum. There is audio that comes out in the exhibit that translates the treaty into Navajo. Very interesting. Would recommend if you're ever here in Winter Rock, Arizona, that you visit that particular exhibit. And as I think Justice Gorsuch, from my point of view, now Heather Tanana can speak directly from the Navajo point of view, but as an attorney for the Navajo Department of Justice who has worked on the treaty a lot, I can say Gorsuch gets it right. The context of the treaty, you cannot separate the treaty from Bosque Redondo. You cannot separate Navajo perception of the treaty from the Long Walk, from Hueldet, from all the suffering of the Navajo people by the aggression of the United States. And so the belief, the understanding, the context of what this guy, by the way, who is Barboncito, this is a rendering by Navajo artist Patrick Hubble of a famous photo of Barboncito, sort of close up. What he cared about and what he talked about a lot was water and irrigation, because one thing that people may not know, but comes out again in Justice Gorsuch's opinion, Navajo was already cultivating agriculture before they were forcibly removed to Bosque Redondo. Corn is extremely important to the culture of the Navajo people. And so it was not that mysterious or strange that Barboncito and others told Sherman, look, we need water. We want flowing water. We want to be able to build our crops out as we used to. And Bosque Redondo is not that, because Bosque Redondo has alkaline, crappy water that cannot grow anything. This place sucks. Send us back. So we can talk about in more detail. I don't want to take any more time from the other panelists, but the treaty and its context is vitally important to understand this case and what it means to the Navajo Nation. Thank you.
Thank you so much, Paul, for that. Next, I would like to turn it over to Professor Tania, who was the lead author or one of the authors on the Dig Deep amicus brief. On this case, the case was cited in oral arguments as it provided real-world context of the dire water needs of individual residents on the Navajo Nation. Professor, would you share the impact of this case and what impact it may have on Navajo residents, and why this case matters from a public health perspective? Specifically, I just want to point out that in the majority opinion, Justice Kavanaugh writes, the reservation contains a number of water sources that the Navajos have used and continue to rely on. What is the actual reality of that statement? Thank you.
Yeah, so one of the things that really came out in the briefing as well as oral argument was the lack of water access, water insecurity that Navajo Nation experiences. It is, when you try and pinpoint exactly how many homes lack water, it's a really challenging data question. No one is charged with going out home to home, building to building, seeing who lacks water and who hasn't. And that's why you see these estimates of 30 to 40% roughly. But certainly the Indian Health Service and their sanitation facility construction program is one of the best databases that is out there. And you can pull up their map. I'll try and drop it in the link. They're tracking infrastructure projects right now, but Navajo is very much lacking basic infrastructure. And so that's what the Dig Deep brief tried to show, that with the lack of federal, really meeting its, what I do think it absolutely is, there is some debate there of like, does the government have to go out and build pipes? And Navajo Nation was saying, no, me personally, yes, that's part of the trust and responsibility is providing water to these homes. And it's why we have the sanitation facilities construction program as part of Indian Health Service. And so I guess that's a very roundabout way of saying, like, there is dire lack of water, both in terms of piping infrastructure not coming out to homes, as well as quality issues, right? There's a study out of Arizona that found that there's traces of uranium in Navajo babies being born today. So even though there are water sources, Navajo Nation pulls a lot of their water from groundwater, the quality of that water source, in some cases we know that it's not healthy to consume, and then others, the residents relying on that source, have no idea what the water contamination may or may not be. And so there was a line in the brief, talking about how Navajos are facing the same water scarcity problems as the rest of the West, and I thought that was totally taken out of context, and states they were pretty persuasive in connecting this into climate change impacts and Colorado River management, which wasn't the issue really being presented. Instead, going back, that the government exercises such control over this resource, and Navajo Nation would be much closer on closing that water gap if they had that assistance of the government in accounting for this asset that they're controlling and helping them plan and analyze, which I think is something they've been asking Reclamation to do for years and haven't gotten much assistance. So the impact on the ground, not just for health impacts, but there's certainly water access has been connected with even educational attainment, economic development, the cultural uses of the water, really impacts just the day-to-day living of tribal residents. And the pandemic helped highlight that. Those that feel like the pandemic is over or even question the science and research that was done associating lack of water with higher incidence rates, the public health research is way more expansive beyond COVID-19. It's been connected with diarrheal diseases, waterborne diseases, right? Higher transmission of things like cholera and hepatitis A. And on Navajo Nation, right? Also, there's limited grocery stores. And so it's easier for families to buy soda than it is to get clean water. And so we also have this connection with higher childhood obesity and adult obesity rates, which then contribute to diabetes. And so, yeah, it matters, right? Closing this water gap matters. Getting clean water to all residents on the Navajo Nation that want it, that matters. And so where we go from here, right? We have groups like Dig Deep, these nonprofits that have stepped forward to try and really put like a Band-Aid on it, right? To do these little cisterns underneath homes. Those are great, but we still need to keep moving forward on these big projects. The other kind of point I would make is that in our health world, when we look at the Indian Healthcare Improvement Act, ISDA, Indian Self-Determination and Education Assistance Act, all of these laws that form the basis of providing federal health services to tribe very much do reference and talk about this special legal relationship between the federal government and tribes. And so, when we wrote the amicus brief talking about these health impacts, these economic impacts, we were trying to connect it back to the fact that the government and Congress has already expressed this intent that the federal government should allocate resources, do what's necessary to elevate Native health to the highest level possible. And so for that to not get carried over in this area was a big disappointment. Yeah, so I could go in for a while too on that area, the fact that we have several agencies with multiple different programs for building tribal water infrastructure, but that they have all been historically underfunded, and that's why we haven't made as much progress as we want. But Again, I'd say the recent influx of money under the bipartisan infrastructure law and the Inflation Reduction Act also showed congressional intent that, this is a responsibility of federal government that should be addressed. So yeah, really disappointed they took such a literal interpretation and wouldn't look at the broader context. I know I spoke really fast, so if there's questions, go ahead and put them in the comments, but I think I'll go ahead and pass it off to the next person there.
Thank you so much, Professor. I just wanted to highlight that in the brief, in Gorsuch's opinion, he does talk about how there are 7 gallons of water that each Navajo Nation individually use. And, I think it's hard for us to actually fathom and conceptualize what that looks like. So I brought one of the little gallon jugs. This is 5 gallons here. So Navajo individuals are using 2 more gallons than this in their daily lives. And that is in comparison to, in oral arguments, they said 160 gallons of water that a normal Phoenix resident uses. So huge disparity in the amount of water and the access to water issues that are on Navajo Nation. So again, thank you, Professor. And now let's turn it over to Professor Fletcher. Professor Fletcher wrote a summary of the case in SCOTUS blog. It's been dropped into the chat as well. In your reading of the case, Professor Fletcher, we wanted to know what your thoughts were on the majority's reliance of saying that the Treaty of 1868 didn't impose a duty on the U.S. to take affirmative steps to secure water for the Navajo Nation. Also, in your write-up, you talk a little bit about Justice Thomas's concurrence, where he argues that the trust duty is essentially made up and shouldn't be affirmed by the Supreme Court. We would love to hear your thoughts on that. Thank you.
Sure thing. So thanks for having me. It's nice to be able to talk about the case. I guess I'll start by talking a little bit about the Supreme Court's jurisprudence on the trust responsibility, and I'll step back in time a little bit to the original understanding of the trust responsibility. At the time of the founding of the United States, framers understood something like this to be known as a duty of protection. And Chief Justice Marshall in Worcester v. Georgia especially referenced the duty of protection over and over again. We call it the trust responsibility now, probably because so much of the United States assets and lands and resources owned by Indian tribes are really actually in the sort of in the hands or control often of the United States. So they have a trust a responsibility in that regard. But the duty of protection is much broader than that. So that's an original understanding that's, I believe, noted in the structure of the Constitution. There is some direct source of congressional powers, such as the Indian Commerce Clause in Indian affairs, but there's also the treaty power that the United States chose to utilize in terms of dealing with Indian tribes way back at the beginning. There's also the Supremacy Clause, et cetera, et cetera. So there's an enormous amount of implied, unspoken understanding with the framers that there was this thing called the duty of protection, a special relationship between Indian tribes in the United States. The majority here is carrying water for the United States Department of Justice on this question. They are reading out the duty of protection. They're in the arena of federal and tribal affairs. This is a huge effort, a long-standing, quiet effort by primarily the Department of Justice, and I'm not talking about the Attorney General necessarily. Not necessarily even talking about the Solicitor General, although the SGs over the years have had a hand in this. I'm not even talking about rank and file ENRD employees and workers, lawyers within the Department of Justice. I'm really talking about high level appellate litigators at the Department of Justice, mostly in the Office of Solicitor General, that sort of make litigation policy and litigation strategy for the United States and Indian affairs. It has been their position for at least 5 decades, probably since the 1970s, if not longer, that there is only one real trust duty, and that's when Congress has passed a law explicitly stating there is a trust corpus, i.e. assets. And in the event that the trust corpus is lost, that Congress has acknowledged that there is financial value to that trust corpus that the United States would then pay as damages to any affected tribes or Indians. That is, for the Department of Justice's perspective, the whole scope of the federal tribal relationship, full stop. That's it. So there cannot, from the Department of Justice's litigation strategy and positions, there cannot be a single, there cannot be any kind of implied obligation whatsoever. I think that this position comes from two places, one of which I think is a place of good faith. The structure of the Constitution effectively prevents an Article 3 court from telling the president in Article 2 and Congress in Article 1 what to do. So there's something called a political question doctrine. So Congress can't, Supreme Court can't tell Congress to pass a budget, for example. There's no way to make that happen. We know that the Supreme Court can't tell the president to invade a country or to stop bombing Cambodia or something like that. That's not going to happen. That's a separation of powers, a core fundamental constitutional policy that exists in the United States. What the Department of Justice is trying to say is that extends also to Indian affairs, that Congress, or excuse me, the Supreme Court cannot order Congress or the executive branch to do anything in the area of Indian affairs. They can enforce the law, they can certainly apply and interpret it, but they can't order either of those two branches of government to do anything. And I'm fine with the Supreme Court saying you can't tell Congress what to do, but yeah, absolutely can tell the executive branch what to do when there is a duty. And fundamentally, what is at issue here in a case like this is what those duties are. Those duties derive from the duty of protection, which is a creature of international customary law that the framers understood to exist. The treaties are a kind of interpretation or a negotiation of what the duty of protection might mean in a given treaty or Indian tribe or reservation context. It's always been that way. We continue to negotiate effectively treaties with the United States virtually every year, 638 contracts, self-governance contracts, any kind of agreement that the United States and Indian tribes enter into is a kind of a treaty. And Indian tribes definitely treat those things as treaties. Those are all renegotiations in an annual basis of aspects of the duty of protection, but there's a lot of the duty of protection that isn't negotiated. Every single treaty involving an Indian tribe in the United States acknowledges that the United States has acquired or possesses a duty of protection over Indian tribes. Congress has explicitly stated what some of those protections are, things like the Department of Justice must defend against trespass actions brought by that affect Indian tribes. It's just one example. But again, the Department of Justice position is because of the separation of powers, there is no duty of protection that is enforceable, i.e. the general trust responsibility. Second argument is that the Department of Justice has a long historical hostility towards tribal interests that's probably going back longer than 50 years and totally rooted in racism. They've sort of whitewashed it to make it look like it's an objective thing, but the Department of Justice has such a long history of opposing tribal interests for racial reasons, probably going back centuries, that just infuses the high-level litigation position of the United States government. There's a question in the Q&A that says, well, why isn't Deb Haaland doing something about this? Where's Brian Newland and all this? I assure you, they have no power whatsoever to influence or to order their lawyers, the Department of Justice, what to do in a case like this. This is purely, I assure you, I don't know this for sure, but I'm pretty certain this is a Department of Justice case. They wanted a case like this to get to the Supreme Court. They want to stamp down the obligation of the United States to Indian tribes. And I don't know why they're so interested in that. There's no good reason for it. And so when, Justice Kavanaugh talks about affirmative steps, really what he's doing is just parroting what the Supreme Court has said, what the Department of Justice is arguing, that, that you cannot order the executive branch to do something in Indian affairs without an explicit written congressional requirement to do so, a duty. The duty of protection actually is that duty. It's a real thing that exists. We can define it. We can look into the common law. We can look into international common law to determine what that is. And the court absolutely should interpret that. Paul, Heather, and I'm sure Heather Whiteman what is going to describe exactly in much detail what those duties are. They're not invisible or made up or illusory. They are all there. And if the court issued an opinion in favor of Navajo and the Congress didn't like it, then they could fix it. But this is pure Department of Justice policy making, and the Supreme Court is just granting it and going along with it, which they've been doing for quite a while in most cases. I was asked to speak a little bit about Clarence Thomas as well. Clarence Thomas has been writing opinions off to the side, concurring and dissenting opinions in Indian law cases since at least 2004. He's written opinions saying that the Indian Commerce Clause doesn't mean what it says, that it shouldn't be interpreted that way. We should go back and revisit all of the cases going back to the Marshall Trilogy and reverse them in a position to fulfill his political wishes. He's now extended that in this case to the canons of construction and just the notion of the trust responsibility altogether. And I just want to remind everyone, this is A, it's kind of a problem, but B, not a single justice, not even Alito has signed on to any of his these secondary opinions or separate opinions he's in which he's asking the court to revisit more than 2 centuries of precedent. I would say this, that there is it's worth studying Clarence Thomas's concurring opinions, especially in this case, I think. It's the first time that he's talked about the canons of construction as sort of being illusory. It's not the first time he's talked about the trust responsibility being illusory. That goes back to United States versus White Mountain Apache in 2003, where he said that there's no trust responsibility. It's a guardian-ward relationship. And a guardian, as you know, can do whatever the guardian wants, and the ward has no ability whatsoever to respond to that. So I'd say a couple of different things as a general matter about all of this. In terms of Clarence Thomas's position, he really is dinging and attacking federal power in Indian affairs in so many different respects. And that's one place where the Department of Justice robustly defends sort of much of Indian law, and that is the powers of Congress. If you look back a week earlier than this opinion, you'll see Justice Thomas write disparagingly about the majority opinion in dissent. They have utterly and completely rejected his position that congressional Indian affairs power is minimal to non-existent. They've completely rejected his position that tribal sovereignty is minimal or non-existent. He doesn't have any votes, not even just the votes. He doesn't have any votes to support that position. And he also doesn't have the Department of Justice. And the Department of Justice will tell you that Congress has virtually absolute and unlimited power in Indian affairs. They would go probably too far the other way. As Dan Ray, my friend and one-time co-author Dan Raybear wrote and defended pretty effectively in an article he co-authored, that the Department of Justice is still arguing that Lone Wolf versus Hitchcock, the guardian-ward relationship with absolute congressional and executive branch discretion and power in Indian affairs is still the law. Sometimes their Department of Justice attorneys get sanctioned for saying things like this, because it certainly is not the law. At least not to the extent that DOJ is saying. That said, there's still plenty of robust congressional powers in Indian affairs. It absolutely is plenary. Plenary does not mean absolute. It means enough power to effectuate a purpose. And of course, the purpose here would be congressional power to manage Indian affairs. So Clarence Thomas is running up against the Department of Justice in some respects by denying that there is really any Indian affairs at all. But we should be concerned about his position on the canons of construction. I think Rick Collins may be one of the only people who's actually delved into the origins of the canons. And I think what we need is another Bill Wood type article, which Bill Wood, as you probably know, wrote plenty on sovereign immunity, the origins of sovereign immunity. Justice Kennedy once wrote a piece, an opinion in 1998 where he said, wow, sovereign immunity was an accident, so we should probably get rid of it. And Bill Wood explained in great detail how that was false. And we don't really have a good origin story for the canons of construction. I mean, the argument's there, you just got to say the words. The argument is the duty of protection. It's the structure of the Constitution. If Clarence Thomas is so concerned about the structure of the Constitution that he's willing to say that the Supreme Court cannot issue an order in Indian affairs to the executive branch, he should also be in support of the canons of construction, because the canons of construction are rooted in the separation of powers as well. Congress has made choices in Indian affairs robust choices to, especially in the last 50 years, to support tribal sovereignty. The Congress has even said repeatedly in sort of the congressional version of dicta that the trust responsibility is enforceable. It'd be helpful if they'd pass a law instructing the Department of Justice to stop lying to us and gaslighting us about this, but Congress has not yet done that. But Clarence Thomas's position on the canons of construction, which sounds like he just thought of it in the middle of the night, or one of his clerks did, wildly inconsistent with the rest of his position that there's no, because of separation of powers, there's no really Indian affairs power. It is, in fact, the duty of protection and the separation of powers that requires the judiciary to defer to Congress and the executive branch on policy positions. So if there is an ambiguity in a statute or treaty, it should be interpreted to the benefit of the tribe and consistent with congressional powers. This is something that everybody has already been saying for literal centuries. It's probably time for somebody to write that article. And I am looking at my watch. I don't have that time. So thank you very much for the opportunity to speak, and move on to the next person.
Thank you so much, Professor Fletcher. We really appreciate your analysis there. And turning now to Professor Whiteman-Runsham, who will talk through the impact of the case from a broader tribal perspective. Professor Whiteman-Runsham, we'll turn it over to you.
Great, thank you so much, and thank you for inviting me to be part of this panel. It's hard to know where to start on the question of how does this decision impact tribes. I think some of that has been covered already by a few of the other panelists, especially talking about the parameters of the federal trust responsibility. So I'm not going to talk too much about that. I'm really interested in thinking a little bit further in more detail about what the decision means in the context of the ability of tribes to utilize the winner's doctrine to secure safe and secure water sources for their citizens and for the building of indigenous nations that we are still, struggling to be able to complete, or the rebuilding of indigenous nations here in the United States. I think there was tremendous fear about potential directions that the court could take with the questions before it in the case. We felt that there were a number of things that were squarely in the crosshairs when this case went up. And, I guess that's sort of a mixed bag with what we ultimately came out with last week from the court. The trust doctrine, the ways in which the court applied its analysis of what the extent of the federal trust responsibility should be is very problematic, and it's going to impact, I think, the parameters of the application of the winner's doctrine and the ability of tribes to utilize the winner's doctrine to secure meaningful responses from the federal government, from the federal trustee, to do the things we need to have safe, secure, healthy Indian country communities. And so that's really where I see, the biggest impact to Indian country being that water rights, as a result of the way that the court has evaluated the different questions before it in this case, are even more politicized than they already were. And let's be honest about it, tribal water rights settlements and tribal water rights litigation are incredibly divisive issues in Indian country and between different segments of the populations in a number of states where a lot of Indian country is currently located today. So the politicization of tribal water rights, I think, is increased through the ways in which the court deals with the questions before it in this case. When we look at the ways in which tribal water rights settlements are negotiated and the process through which tribes have to go in securing tribal water rights settlements, a lot of the sort of nitty-gritty details that are part of that process are going to be impacted by the way that the court analyzed the extent of the trust responsibility in this case. So I think that's where I see the biggest immediate impact on Indian country here is how are tribes going to leverage the different legal and factual questions that go into those negotiations going forward. There may be less leverage on some points where tribes were, maybe previously able to assert a quantifiable claim for damages that can be offset to claim funding for infrastructure that then is politically supported at the state level and the federal level. So some of those areas are going to be more challenging going forward. I don't think that those negotiations are made impossible going forward, but I think that there's going to be more work to do in the future. That's, what I see as the practical implication from the case. There are a lot of other problematic aspects of this that, are just frustrating, and that, we're going to have to continue to work really hard to rebuild and maybe to bolster our claims in ways that are more robust and even more detail oriented than they already have been. And people work really hard on these historical trust claims and historical water rights claims. We bring in historical experts to analyze and document what the tribe understood at the time that a treaty or an agreement was made between the federal government and the United States. It's hard to read the majority opinion that completely disregards a lot of that, or just sort of, that just doesn't really give any real significance to a really compelling historical record on the part of the Navajo Nation. That's incredibly frustrating to see. Where the majority opinion, states that the assertion that the Navajos' understanding of a permanent homeland entailed access to water and help in getting that water to their people in an arid part of the country. The court says that assertion finds no support in the treaty's text or history, which I think is completely untrue. So how we battle back from that type of disregard for the historical record or mischaracterization of the historical record is going to be an ongoing challenge for us. It means we're going to have to, basically be able to hit people over the head with these historical facts, because all of these cases really, are so laden with history and the historical record utilization of historical documents that underscore all of these things that we know to be true. So that's going to be difficult. I think that I don't know how much more clearly the Navajo Nation could have demonstrated the understanding of their people at the times that their treaties were made, and the ties of water to everything that was envisioned for a permanent homeland there. It's really frustrating to think about what could satisfy what the court apparently found lacking, or the majority of the court found lacking on that point. As far as a couple other questions that I think I was asked to address, what do we make of Justice Thomas's concurrence? I don't make much of it. I agree with Matthew that, and I take tremendous solace in the fact that he's alone in his concurrence, that other conservative justices did not join him in that concurrence. So I take some comfort in that. It's frustrating to read again, the minimization of the trust responsibility is, it's a problem, and we're going to have to continue to work to address that and to, show the court that there are different paths towards finding a trust responsibility, and just a mere statute and explicit wording in a statute is obviously, not what the Indians understood at the time that they were negotiating treaties or negotiating agreements. The pointing out of Justice Thomas's statement that, hey, maybe the trust responsibility just means that, these Indians trust the federal government to do the right thing like anybody else in the world does, is, completely disingenuous. And I don't think he seriously believes that that's any kind of a valid description of what the trust doctrine is supposed to mean, because of course he follows that up with, contrasting what a common law trust is and what that means, but, of course, takes a lot of steps back from, finding that should apply at all to the questions in a case like this. But, where he contrasts general moral obligations with specific fiduciary obligations, I think we know that Justice Thomas even probably understands that the federal trust responsibility means more than just, you know, we trust you guys, you're gonna do good things for us. So that's what I make of that particular language in the dissent that I think was part of a question that somebody had for me. You know, I think the case itself, it could have been a lot worse. We're a little bit relieved that, you know, the winner's doctrine remains intact. I think that securing and building winners-based claims is going to, like I said, require some additional effort and resources going forward. So there's more work to do, as there always is. And, you know, underscoring again what other folks have said, that the relief sought by the Navajo Nation in this particular case was fairly minimal, and really things that it's hard to understand why the federal government hasn't taken some of those requests and gotten to work on them, even since cert was granted. It's hard to understand that, right? So you know, I think that we'll see where the negotiations between the Navajo Nation, federal government, and the state of Arizona go in the future. Hopefully they'll go in a good place, because like we said, this case really does put those questions into the status of being worked out through a negotiation amongst sovereigns at the end of the day, and political will, and, you know, making political alliances and securing agreements to do the right thing that, you know, hopefully we'll be able to do. And you know, it underscores again, I think, the importance of our political will being exercised as Native peoples, and getting leaders in place who will steer these processes that are again going to be more governed by political considerations perhaps than legal considerations, at least for the time being, steering them in the right direction and having leaders who will do that. So those are my thoughts on the case and its current practical implications.
Thank you all so much. Thank you, Professor. So right now we're going to turn into some Q&A. We have quite a bit of Q&A in the chats, so we're going to turn to those. And I think one of the bigger question is, what happens next? You know, Justice Gorsuch, at the end of his opinion, talks a lot about how the Navajo are in this revolving line of going to the DMV and stuff. So, and then over the weekend, on Facebook Live, via Native News Online, President Nygren was on with one of the on the panel, and he was talking a lot about that the nation is hopeful for working with the states in terms of like next steps and going forward. Paul, I don't know if you were able to share a little bit about the next steps or what we're seeing, and where is the Navajo going to be in this ever revolving line of at the DMV?
Mm-hmm. Yeah, sure. I mean, I think it goes without saying I'm speaking in my official capacity as an attorney for the Navajo Nation, and therefore am speaking the official position of the Navajo Nation, not my own. But as you mentioned, Micah, there has been a lot of public statements by the president, by our legal team. I also want to acknowledge Shai Dvoretsky and his team at Skadden, who worked on this case in the Supreme Court. I wanted to say that our position remains the same. That, and I think Heather Whiteman-Runson particularly alluded to this, our view, it's a very limited decision. All it says is, under the specific language of the Treaty of 1868, the courts cannot compel the Department of Interior to do an assessment on the nation's water needs and create a plan for those needs, period, end of story, zero, that's it. Does it have anything to say about the nation's actual water claims to the Colorado River? Only in the positive sense, actually. There were a lot of arguments floating around. I think if you read the state of Arizona's Department of Water Resources brief, you can see where they were going with this. For some reason, the state of Colorado felt the need to file its own brief in the Supreme Court to fight this. And they seem to have this sort of end of the world Armageddon sort of sense that this case was going to completely upend the entire structure of the Colorado River, to which they had beneficially relied for many years, of course. But it didn't do that. As Heather said, it upheld Winters. Winters is valid, it is the law. Both opinions, the majority and the dissent, assumed that there was a valid claim of the Navajo Nation, from our point of view, to the lower mainstream Colorado River. As we said, Justice Gorsuch sets out essentially a roadmap and perhaps the most stunningly powerful language in almost any opinion you're going to find, basically said the nation must do what it has always done. Since Bosque Redondo, it's going to have to do it itself, period, end of story. If the federal government's not going to do it, we're going to have to do it. And what does he say? Can there be any illusory second guess that the nation has the right to intervene and has a right to push forward its claim to the lower mainstream Colorado River? Absolutely not. Zero, period, end of story. Even Kavanaugh had to grudgingly put in a statement in the majority, well, the Navajo Nation can file with, a laundry list, a string site, including Arizona v. California. Whoops. So the state of Arizona's argument of the entire litigation, oh no, you're foreclosed, res judicata, the United States didn't raise a claim, you're done, too bad for you. Sorry, that didn't carry the day. And in fact, from a positive reading of the case, it remains a viable claim. So stay tuned. It's not the end of the story. Thank you.
And Mike, I kind of add on to that. I'll say, we're in a very different place now than we were 5 years ago, 10 years ago in Colorado River management. At the Colorado River Water Users Association, there's a big annual conference every year, and Tom Bushosky, Arizona Department of Water Resources, said on the stand in front of everyone, I don't know why this wasn't in some news story, but that tribes should not have to agree to more junior water priority dates in order to settle and get water infrastructure projects. Because with our water rights, you have your adjudication and then settlement, and you don't get infrastructure if you adjudicate it. Often, sometimes you can negotiate that in the settlements, and that is a big deal. So when we're talking about the human right aspect of every home being entitled to water, there's been a lot of movement there. And again, tribes have given up senior priority dates for those infrastructure projects. And I think, what we're hearing is, and holding these, state representatives to their word, they shouldn't be forced to do that anymore. So little progress there. We'll see.
Okay, following up with that, another question that we have in the chat is, does the Supreme Court decision mean that individual Navajo water users and the Navajo Nation as a whole are prohibited from using water from the Colorado watershed, or is just extremely limited?
I'm sorry, just to cut in again, absolutely not. Zero, end of story. There is no effect on the nation's claims to the Colorado River, period. No one should tell you otherwise. That is the message from the Navajo Nation. Business as usual. We're coming for the water. Thank you.
Okay, great. Let's see. So one of the other things that I kind of wanted to pull from our discussion is a little bit, especially from the majority opinion, is there was discussion about and focus on or highlighting of the 1849 treaty. But in Gorsuch's dissent, he really just focuses on the 1868 treaty. Is there any purpose for that? And why does the majority spend any time talking about the 1949 treaty?
I don't really have a good answer for that, but I wanted to highlight something that I noticed over the last couple of weeks in the Supreme Court's opinions is that when the justices are writing in opposition to tribal interests, they invariably have brought up the warlike character, the so-called warlike character of Indian people. And, I think that's a concerning change. I don't remember the court spending so much time since Bill Rehnquist died talking about Indians and wars. And a lot of these treaties were not a result of war. They were the result of sometimes, just the right thing to do. And I don't know. I'm not really sure where to go with that. I think that it concerns me that in the chambers of the Supreme Court this term, that when people are talking about Indians, they were talking about war. And I think that's why that treaty is discussed in there with such detail. But I really don't know.
I'll forego any response to any of the other questions, but I actually have a direct answer to this question. The Navajo Nation, in its brief to the Supreme Court, connected the 1849 treaty and the 1868 treaty. And what Matthew was saying about protection, that word appears explicitly in the 1849 treaty. It says the protection. And it has something else which only one other treaty has. And it has I found, maybe I'm wrong about this, but I think only the Apaches. And it says the United States shall legislate. It has that explicit term for the prosperity and happiness of the Navajos. And I forget if it says Navajo tribe or Navajo people. Now, not to bring up Brackeen again, because I'm sure we're Brackeened out, but that was a sub argument of the Navajo Nation in the lower courts. Well, now, ultimately, as you know, the opinion said there was no treaty claim made and there's no treaty that supports ICWA. We forewent that in our joint briefing with the other tribes. But that is important language that we take seriously in the 1849 treaty. So for at least the Navajo Nation's representation to the court, those are they're all interconnected in terms of what we believe the United States has said and stated in those treaties. Whether different Navajos agreed to the terms of the 1849 treaty or the 1868 treaty, because not all Navajos were at Bosque Redondo when they negotiated the treaty, the United States said a whole lot about how it perceived its relationship to the Navajo Nation, both in 1849 and 1868. And I will surrender my ability to answer the next few questions.
Thank you so much. Well, unfortunately, the next question kind of has a little bit related to an answer that you previously gave, Paul. So you're not quite off the hook. One of our questions is, since the court essentially did not understand the nature of the Navajo Nation's complaint, does preclusion prevent any future cases about the assessment? What recourse is available when the Supreme Court totally misses the point of the question? Can there be a cause of action based on Winters or other source of law?
I will defer to my esteemed colleagues on that question.
Nobody wants to answer? Maybe you better answer, Paul.
I don't have an answer. That's why I'm kicking it to you guys. Now, I don't think I'm in a position to state a position of the Navajo Nation on that question as to whether there's preclusion in the future. So I'm just not going to be able to respond in my official capacity. Thank you.
I'll speculate, and maybe a little bit of a stretch. You know, when we talk about treaties and we talk about the denial of rights in a treaty, one of the things that is amazing to me is that in the last half century in particular, especially with the rise of the treaty fishing cases in the 60s and 70s, there have been lots of efforts by states and private parties to go to Congress to say, hey, you know, one way to solve all this is just for you have the power to abrogate Indian treaties. Why don't you abrogate these treaty rights? And Congress has never done it. I mean, they've modified them and, you know, in some narrow instances have, you know, done some things that look like an abrogation of an Indian treaty, but they never have. And the big reason is the takings clause of the Fifth Amendment. I mean, if you abrogate the treaty right, you have to take the value under a takings analysis of just compensation, you take the value of the treaty right, multiply it by forever. So that's a lot. And the Department of Justice will do anything in its powers to prevent such a lawsuit, because they know the chances of them losing hundreds of billions of dollars is very, very real. And you know, this kind of thing would make Cobell small. So Congress can't abrogate Navajo treaty rights and to water unless they want to pay for them. And they might actually choose to do that, but I believe Navajo is going to charge a lot of money for that. So I don't even know that the United States could afford to pay Navajo for its treaty rights, even if it wanted to. And that to me is it's sort of a big bookend to the one side that we haven't talked about yet. And so what is the future going forward? Well, Navajo is going to be a player, and they can't go away.
We have several questions kind of related to the implications on treaties and the Navajo's treaty duties and kind of what the universe looks like in terms of like future impact or future support for treaties. One guest writes in about would an executive order be something helpful in supporting treaty duties? Are treaties that the U.S. entered into with other nations, other sovereign nations, how are those duties with the how should those duties be dealt with? You know, how will any breach of duty claims kind of come forward, and does this case in impact have any impact on other tribes? I know Professor Whiteman runs him. You talked a little bit about that, but you know, what is the effect on treaty tribes with treaties going forward?
Are you still muted, Heather?
Yeah, sorry, I was struggling to get unmuted there. Yeah, I mean, the ongoing impact, I think, is, you know, kind of like I said, that there's less of an ability to assert an implied duty, and that, you know, finding ways to underscore what is explicitly or otherwise to, you know, bring those understandings more clearly into consideration before future courts is going to be really important. You know, and there was that question about, and I was trying to find it back in the Q&A so that I could read what the last question about issue preclusion, what that was. I couldn't find it, but you know, after the Crow Tribe's victory in the Herrera case, you know, the state of Wyoming came back and asserted that we'd previously lost a case, even though it was, the question was overturned in the Herrera decision. And until recently, the Crow Tribe was still, you know, fighting against that issue preclusion defense that the state of Wyoming asserted to keep the Herrera decision from being fully implemented, and to keep the tribe from accessing the right to hunt on federal, unoccupied federal lands within their state boundaries. Basically, I think that what we see going forward is, if you're in a hostile political environment where a state administration is opposing the ability of tribes to assert and benefit from rights that their ancestors secured through the terms of negotiated treaties between two sovereigns, that's something that, you know, we're going to continue to battle. We've been successful. It takes time to get through and resolve those things, but, you know, utilizing the historical record appropriately and effectively is something we know how to do. We'll keep doing it. Treaty tribes in particular, you know, being able to assert and document our understanding of the treaties and what they were supposed to mean, and really, you know, bringing context in to inform judges and the general public as well, to support our rightful exercise of our treaty rights and our access to the resources that enable us to continue to be who we are, to build our communities, and to move forward into the future as Indigenous peoples in this country, and to control and legislate appropriately, to regulate resources, regulate access to those resources on our own terms. Those are things that we'll be doing, right? And, you know, I think that the importance of tribal lawmaking isn't something, it shouldn't be disregarded here when we look at what the federal government has said and what the courts here are saying about the extent of the federal government's understanding of its obligations. Tribal nations can also legislate and make policy and affirmative law and affirmative statements about what our understandings of those are, and what our own societal understandings of rights to water and access to water and significance of water resources should be. So I also encourage us all to continue doing those things as well as a matter of tribal law.
Hey, Heather Tanano, you're gonna say something? Yeah, no, say.
Yeah, I was just gonna add, like, I mean, like direction from the top, our federal government, executive orders, presidential memorandum. I mean, you know, office OMB can also even do these cross-agency priority goals that help give direction to agencies to work together. Those are all great. They're not super enforceable though as like a legal mechanism, right? But I will say, you know, we have been pushing very hard to try and get an EO out of this administration related to water. I think we're hearing there's a little bit of EO fatigue. Is that going to happen or not? But I think not being enforceable set aside, like there are a ton of technical assistance programs out there. And if these agencies would just work together and be directed, like this assessment could have happened by now. And so to me, it just seems like the federal government pushes back a lot when, you know, they don't want to be required to do something, but on the side, if they voluntarily do it, there are some really great employees, some great success stories. We've seen a big infrastructure projects being put in place But just right now, it's like on tribes being persistent, establishing those relationships with federal employees, and some employee just, for whatever reason, out of the goodness of their heart wanting to do it. So, they should happen, but like those also are not in the end going to be these enforceable tools against the government.
Before Paul goes, can I add one more thing right on top of what you just said, Heather? Nobody, and I'm sorry I keep rambling on about the Department of Justice, but there's never been a tribal citizen who's ever been a political appointee of the Department of Justice. There's never been a lawyer in the Office of Solicitor General who's been who's a tribal member, and that's on purpose. Informally, a bunch of us around Indian country have been told to our faces that SG's office will not hire an Indian person because they cannot be counted on to be objective, and that's a very serious problem. The Department of Justice is still in the 1970s when people like Antonin Scalia were running the government, and they haven't changed really their positions on a lot of things, big picture stuff when it comes to the trust responsibility since then, and that needs a huge update. And the only one who can really do that is the president, and even Obama wasn't willing to do anything on this score, so I'm not sure that it'll ever happen. Go ahead, Paul.
Yeah, thanks. Just very quickly, and in a sort of small lens on this case. Does this case then mean that the treaties don't say what the Navajos believe they say? Absolutely not. Does this mean that the Supreme Court, a majority of 5, have decided under the Hickory standard that a court cannot force Interior to agree that this is what the treaty means? That's what we think it says. But where does that leave us? And to put in the larger lens, if there's, to sort of be an amateur Supreme Court analyst as to what are patterns in all of these cases, Brackeen, Coughlin, which doesn't give its due because it came out 2 minutes before Brackeen, I think, Congress. That what Congress does and think is going to be paramount in all of these things. So the Supreme Court has expressed that, well, Congress can do this. Congress did that. Congress did abrogate tribal sovereign immunity in Coughlin allegedly because something. Look at this garbage language. See, it's so clear, right? So really, it seems to me, the treaty remains a political document that creates a sovereign to sovereign relationship, and both sovereigns are still in play. It's not an old 155-year-old document, as Kavanaugh sort of crassly characterized. Well, it's not our problem. If you want to update it, where do you go? Congress. But it's a living, breathing document with important promises for that government that the Navajo Nation will continue to assert. So does it mean the treaty doesn't say what it says? No, it just means that under the standard, we can't enforce it. It still exists, and we will continue to push it. Thank you.
Thank you, everybody. We have a question specifically for Professor Whiteman-Runson. Do you think this opinion might affect the United States position regarding its duty to bring claims and defend tribal water rights in general stream adjudications? Do you think it will change how the U.S. views federal contributions to tribal water rights settlements?
Right. As to the first part of that question, there's already a lot of discretion involved in the United States agreement to affirmatively bring claims on behalf of tribes for water resources, or to protect water resources, or to adjudicate water resources. I don't see anything in this opinion that would limit that discretion, certainly, and if anything, I don't think there were really any limits on that discretion to begin with. So that's my answer to the first part of the question. I don't think there's a big shift in the dial there as to the United States exercising its duty to affirmatively, bring litigation on behalf of tribes or along with tribes to quantify or protect water resources. As to the second question, the second part of that question, I think it's possible that there could be some changes to the ways in which the federal government evaluates potential claims, the value of the waivers that are generally required from tribes, waivers of potential claims that are part of the quantification of a tribe's waiving of something of a measurable monetary value to offset the costs of infrastructure that's typically part of Indian water rights settlements. So there could be some implications there.
Anybody else have any thoughts that they want to add on, or we good?
I'll just say, I mean, the bipartisan infrastructure law, put forth $2.5 billion to finish outstanding settlements. And so that's where I just think this decision with recent action by our Congress, they're not lining up. Like Congress has actually done things with those infrastructure law, Inflation Reduction Act to invest. And it's again based on treaty and trust, special legal responsibility. So, I mean, to the extent they need to clarify it, I guess they should, but there has been some good things happening right now in terms of the water world that, again, 5 years ago, like didn't exist at all.
So one of the questions that we do have is related to international law, and just curious to see if anybody has any thoughts on it. So it says the Navajo people have used water from the Colorado River watershed, particularly the San Juan River, long before the existence of the 7 states of the Colorado River Compact. Since the Supreme Court now says that the U.S. has no obligation to provide water to the Navajo Nation based on the Treaty of 1868, would the Navajo Nation be in the right, according to international law, to unilaterally begin diverting or damming water for its own use?
I'll jump in on the first part. I think that I talked earlier about the duty of protection, which is a creature of customary international law. It always has been, and it's been modified to some extent individually by the tribes in the United States. So there still is an international customary law on the duty of protection, and it's been modified too. It's the United Nations Declaration on the Rights of Indigenous Peoples. I mean, Jim and I wrote about the duty of protection under international law back in the 90s. And so there is an up-to-date current sort of understanding of what the duty of protection means in international customary law. So, hey, if you could find something in there that says you can divert water, then I think you have a plausible basis under international law to make an argument like that. I don't really know. I don't know much about the United Nations Declaration, but I would guess that it would be a really hard thing to do, and you'd probably have some pretty strong pushback on that. But I would argue that UNDRIP actually is law. It's the common law of the United States. It's international law, and that's not all that particularly unusual. I mean, much of federal Indian law going back to the beginning has been influenced by and partly formed by international law. I mean, the canons of construction arguably are also elements of international law. So I'll leave it at that. That's about the extent of what I know.
Well, and I'll just add a little bit to that because I can't help myself. As far as the UN Declaration on the Rights of Indigenous Peoples goes, I think that most of us regard UNDRIP as contextualizing existing international law in the context of the very unique rights of Indigenous peoples. So UNDRIP, of course, has a few articles that deal with lands, waters, and resources, and also public health standards. So I think that if we looked at diverting and damming water for its own use, I think we'd have to question, what's the purpose of that? Most likely to meet the needs and, promote the physical health and well-being and economic security and political security of Indigenous nations. So, certainly there'd be some support for taking those types of actions under international law, under, the articles of the UN Declaration, which is, again, a contextualization and application of existing international law into the context of Indigenous people's rights. So I think, you could certainly find some support for that type of an effort, an affirmative effort by Indigenous nations through some of those types of terms.
Yeah, and I just want to reiterate what Paul was saying before, is that this decision, it does not impact Navajo's water claims, right? And what their water rights will end up being. And they've, in Utah, New Mexico have resolved those. Arizona, they have not, right? Our 1922 compact, law of the river, divides out our upper and lower basin. So this kind of unresolved or unknown water, what that may be in the lower basin, like they can move ahead with their claims, and they've said, right, they're going to move ahead with settlement discussions. If they don't work out, they'll go back to court, and as mentioned in the decision, right, no one should be objecting if they have to go back to court. It's just that all takes time. And for me, this decision, had it turned out the other way, it would have happened faster. You know, they would have gotten some assistance with the information to be even to engage in negotiations, right? Some more knowledge about the water sources and their need, it would have happened faster. It'll still happen, just it's again burden on the tribe to do that, and good-hearted federal employees, we'll see.
Thank you. One of the questions that we have coming in is about just the news facing the Supreme Court justices today. You know, when this case is troubling because the majority of the justices are facing ethical issues, Thomas and Alito specifically, from accepting gifts. Was there discussion by the Navajo Nation to seek recusal of troubled justices? Congressional fixes to the aspect of the troubling aspects of this and troubling aspects of the case?
I don't know if everybody's waiting for me, but I have no comment other than a motion was not filed. Thank you.
I think it's pretty well established that you don't move to recuse the justices formally, because they don't have to. There's actually no law that requires them to recuse. They could be a named defendant in a case and they don't have to recuse. There's nothing at all in the Constitution that requires that. And I saw this in the Q&A too. If Congress passed a law saying they would have to, I guarantee you 6-3, the Supreme Court would strike it down. And you know, we also have to keep in mind that our currently favorite justice is also one of the people that has received some bennies from people. So we should be very careful about what we do. I will say this, it's my understanding from the grapevine that there are ways to get the justices to think carefully about what they're about to do. Wasn't that long ago that there was a case involving Alaska. What was the Alaska case? It may have been the Yellen case. No, it wasn't. But the Chief Justice argued the Venati case back in the 90s, and there was a case involving Alaska. Oh, I think it was at the cert stage where he recused because he had once represented the state of Alaska. And so that wasn't a formal request, but it was certainly, there were ways to communicate these things to the justices, I think.
Thank you so much. We have several questions in the chat asking about what individual tribal members and citizens can do. Does anyone have any suggestions or thoughts on how tribal members can really start advocating for their rights and, you know, making sure that this that water rights are protected for tribal communities?
I don't live there, but I would vote, you know, vote in Arizona elections and take over the Arizona state government, negotiate a good deal, get good people in there.
Yeah, I think that's important. You know, like I said, this process is going to be increasingly politicized, and having leaders at the state and federal governmental levels, as well as our local tribal officials who understand and know that they're accountable back to Indian country is going to be increasingly important after decisions like this. I think it would be interesting to hear or to learn more about what provisions currently exist in the Navajo Nation Code or in cases from the Navajo Nation's court system about individual entitlements to water and resources, and you know, to what extent the Navajo Nation has legislated a process through which tribal citizens can, you know, pursue having water allocations that they can, you know, utilize to, you know, farm or meet their domestic needs, things like that. I'm sure that some of those systems are in existence and currently being developed as well. So there's a lot to know and understand about your rights as an Indian person from your tribal legal infrastructure, as well as from the federal, what you know, the federal courts and federal statutes say as well.
Yeah, and I'll just add on top, I think there's still like the average American has very little understanding of like the indigenous history in this country still. And so continuing to share and educate, and I know this is a huge debate, right? Why should the burden be on us to do that? You need to go out and learn. But what I've just seen is just on a human nature level, when you connect as human beings, then I think you're able to make connections. You know, like, so say Utah, we're a very conservative legislature, but our governor had some sort of personal connection to a trans person. And so when a bill came through, you know, banning the sports and access to bathrooms, he was against it, even though he's a very conservative LDS member. And so those personal connections you can make, I just think they can have impact. And then continuing to encourage our youth to go into law, to go and represent, because I know when I clerked, I was the first Native that my judge had ever had in his chambers. And after I left, he mentioned how much he had learned from having me in there about experiences that he didn't know about. And so sharing, go and represent when you can, encourage our youth, you know, future lawyers are needed.
So I'm just going to end very basically with make your voices be heard at every level. Talk to your tribal leadership, talk to your state leadership, talk to your federal leadership. You guys are on the ground. You live this every day. This is your lived experience. Thank you.
Thank you all so much. I really appreciate it. We are drawing to a close. We did have a question in the chat. Somebody was wondering if folks felt comfortable sharing their contact information to speak with their class later. If you are, feel free to share that out, our panelists. Otherwise, I just want to close and say thank you all for being here, for listening to this very important panel. I also wanted to highlight one of the books that Justice Gorsuch had cited pretty frequently when going through the history of the Navajo Nation, and it was this book here. So if you are interested in learning more about the history of the Navajo and seeing where Justice Gorsuch was pulling a lot of his historical context, that book, The Diné and History of the Navajos, is the book that it was coming from. And thank you all so much. And if you have any questions or follow-up for individual panelists, please send it to our email. When you were registering, it was there, the Native Nations. There we go. Native Nations law.ucla.edu, and we can forward on your questions. Sorry, we didn't get time to answer everything. And then again, on our Native Nations Law and Policy website, in the events page, we will have more materials posted, as well as the recording if you would like to share it. Thank you again. Thank you to our panelists for sharing your time and your expertise. Thank you. Yeah.